Counsel?
May it please the Court. My name is Robert Jimenez. Good morning, Your Honors. I represent the appellant Sandra Castillo in the instant appeal. At this time, I'd like to reserve 2 minutes for rebuttal. To begin with, I actually was hoping to take a step back for a moment to make a general comment. No doubt there's been thousands of foreclosure cases on appeal in the state and across the country, but not one has presented the issues in the context of Florida standing law. And I think that's where we should begin today.
Florida what law?
Florida standing law. There have been thousands of cases, but none of them have raised the issues in this context, particular context. The first issue, plainly, is, as Your Honor saw in the brief, whether a defendant borrower can challenge the plaintiff's trust standing by pointing to violations of the trust documents. And from what Your Honor saw in the brief back and forth, there's really a lot of argument about 2 cases in particular. Shale Development, Corp versus Kirk, and Martin Properties, Inc. versus Florida Industrial Investments.
But your client's not a party to that trust agreement.
No, Your Honor.
Not a beneficiary of the trust agreement.
No, Your Honor.
And, your client is somebody who hasn't paid their mortgage, correct?
My client has not paid the real party in interest, which the record shows is not this appellate.
Now, the original promissory note and mortgage, were they ever handed over below?
At the summary judgment hearing.
So your client hasn't paid. The original mortgage has been what I have to ask the question that Judge Shepard asked before. What are we doing here today?
Quite a lot, Your Honor. And actually, I'll premise it this way. 40 hours ago, I received a notice of supplemental authority from the appellate. And what that said was that there was a case in the Middle District of Florida that was just handed down a couple of weeks ago, and it brought up that very point. It said what they wanted to say, which is that the borrower doesn't have a right to challenge these trust documents because they're not a third-party beneficiary of it or a party to it. That's the privity-based standard. The issue, though, is Florida law has absolutely rejected that for 4 decades. Florida law on what standing is to challenge is premised in those 2 cases.
And what's your best case?
Martin Properties, Inc.
And what does that case say?
In that case, there's the absolutely analogous situation. There, I'll just go into the facts a little bit. One party, Florida Industrial, had assigned, it was an assignment of a right of redemption to another party. NPI wanted to challenge it, and it was the absolutely same argument. You're not a third-party beneficiary, you're not a party there too, you have no standing to challenge. The 4th District Court, holding based on the previous case from 1971, Shale Development, so it spans at that point 30 years to this point 40, they rejected that outright, saying that is not the test. That is not what standing to us is here in Florida. Standing is based upon having a sufficient interest in the outcome of the litigation, not privity. Privity has been absolutely rejected as the standard of standing in the state for over 40 years. And so after he comes to court...
So in other words, if there was some violation of this trust agreement, notwithstanding the point that the individual who actually foreclosed this mortgage had the original documents in its hand, and your client hasn't paid, which means absolutely that your client is going to be foreclosed and collected again, that there is some harm to your client as a consequence of something that happened between some other people somewhere else out there in the ether. Tell me precisely what it is out there in that ether between those people to which you are not privy that actually has your client 1 grain of sand of harm or rights.
Precisely. And I think you're asking, I'm going to answer precisely as you asked me to. I think what you're really asking is, what is my client's sufficient interest in the outcome of litigation?
No. What is your client's really interest in what happened with these other people, since your client's interest in this litigation is over? You've been foreclosed. Your client didn't pay at all, and the original documents by the person who was due the money have been submitted. So now tell me how what happened up there has any effect on what has already happened here.
Okay. Well, I would disagree that the party that has the right has garnered that judgment, but what happened was they violated their trust documents and sued my client, alleging that my client owed them and their trust a debt. We proved, as a matter of law, that their client is not owed any money because their trust does not own the instruments. Now, there's two things.
Instruments were turned over, were they not? So that is no longer up for grabs. So other than that, what do you have?
Well, the issue is that because they don't own the instrument, and because we're talking about a trust,
They
the very
have
act is
the
void.
documents. They have, isn't that between them to duke out? Your client is held harmless at this point. There's nobody else to come get your client on this note and mortgage.
We don't know that, Your Honor. That's not in the record. I have no idea if there is another party that is going to allege that they own it, but nonetheless, my client has been sued by...
The original of that note and mortgage are in a court file.
They are, Your Honor.
So there's nothing
Nobody else, because the law in this state is that in order to foreclose, you must produce the original documents. They are there. They are in the court file. Your client is completely protected.
Well, I think there's something else about what the law says in the state about that.
There isn't anything else. The originals have been put in. If you had to reestablish a note and a mortgage, then the person who is reestablishing them would have to come in and basically agree to indemnify or hold harmless the individual, saying, if someone else comes forward now and says they own it and not me, then I'll be responsible. But this is not even a reestablishment case. The originals were put in. They're there, and it's over. It doesn't matter who else wants to say they own this. As far as your client's concerned, it's over.
It seems that your entire argument is that you were never put on notice of the chain of ownership. Does it matter who owned it between the two times? I mean, there is no endorsement other than when it's produced, and the original is produced. So when the bank has the original and says, okay, now this is the original, and it's not been endorsed by anyone else, and we're in possession of it, do you care who may have had possession of it in between, or who may have had ownership of it in between? It doesn't matter anymore.
Well, to respond, Your Honor, I think it does matter respectfully because Florida law tells us that it does. There's a variety of cases cited in my briefs from cases actually that the other side cited, like Johns versus Gillian.
But there are a number of federal cases out there that say you simply don't have standing to assert any legal rights if you're not, you're not a party.
I absolutely concede that those federal cases say that, which is why I already spoke of the cases that were given to me recently. But the problem with those cases, and actually I'll talk about the Canella case, which is one of those, the one from the District of Florida. Those federal cases fail to apply our law. Florida law on this issue of the right and the standing to challenge is fundamentally different.
Do you have a single Florida case that says when an original promissory note and mortgage are filed in the court foreclosing a mortgage that the person who's being foreclosed has any standing at all to question anything that happened up the chain of title?
I do not have that case, Your Honor, because no prior case...
Counsel,
if I may make the point, Your Honor, the reason I don't have that case is because no prior Florida case has contemplated these issues in this context. That's why. We're the first ones to raise it. The litany of cases from federal courts and from other cases that the appellee cites aren't going to say that. Previous cases aren't going to say it either because it's just never been raised before.
Counsel, we've let you go way over your time, but we will give you a minute for rebuttal.
Thank you.
Good morning, Your Honor. Diana Maxson, representing Deutsche Bank. I'd like to reserve 2 minutes for rebuttal.
You don't get a rebuttal, counsel. You just give it to us straight for the next 10 minutes.
Okay.
If you feel you must.
I would just like to add that based on the supplemental authority that we supplied the court a couple of days ago, this is new law. It's new law everywhere in the country. In 2010, when this defense was first raised, we filed a reply to the defense asserting that they're not a party and they're not a third-party beneficiary. We had no case law at that time. It didn't exist. But since about June of 2011, these cases started to emerge out of the federal courts. And those are I chose 4 of these cases to give the court a sampling. But I'd like the court to pay particular attention to the Walker and the Edwards case. That was Pennsylvania and Wisconsin, I believe, where they have a similar law similar to Florida in that they use the UCC. And those 2 cases in particular resolve both issues that were presented on appeal here. Number one, that the defendant, the borrower, doesn't have standing to assert any violation of the PSA regarding the standing, the assignments, or the endorsements, or the lack thereof of anything. But what Walker and Edwards also resolve is the second issue, which is that The defendant's position is that New York trust law controls the situation, and these two cases say that, no, if you're a UCC state, the UCC controls, and that's what Your Honor is saying.
Because if I
We have
were
the
the
original
person
note.
holding this bearer note
Correct.
and had it, then I would be a happy person because I wish it to foreclose.
That's right. Whether you were entitled to or not, you hold it. So the Walker and the Edwards case give a very nice summary of the UCC, the application, and the interplay between the UCC and the New York trust law. So I would urge the court, if you're going to issue an opinion on the matter, because this type of defense is so prevalent right now, and it hasn't reached the appellate level in our state, but it has in a lot of other states. And I think it would be very, very helpful for all the people engaged in foreclosure to have a decision similar to Walker and Edwards that will walk the attorneys and the judges through what the thought process is, and I would urge this court to adopt the reasoning and the holdings in those cases.
Thank you, counsel. Counsel, we'll give you 2 more minutes.
Thank you, Your Honor. May I please the court once more. With regard to the UCC, again, the text of the UCC itself and the decisions interpreting the UCC do not contemplate the existence of an external factor that would prevent enforcement of the instrument. That's never been argued before. And that was why, in my brief, I rely heavily on those cases that tell us what standing is. I concede that those federal cases say what it says. They adopt the privity standards.
But that would be a problem between Deutsche Bank and everybody up the line from you, because in this state, with that bearer bond and the bearer note and everything, and you're out now. You're finished. Your client, although they lost their property, is done with these folks. There's not going to be any take back for your client. There might be some argument between Deutsche Bank and everybody else in this chain, but they're stuck with it, not your client.
Well, from the interpretation that I had of the Martin Properties case, it's from that I gather that I think the opposite position is actually what the court should employ here. Without question, the privity standard is the way the appellee wins this case. That's it. And in the law for 40 years, our state has rejected that. Your Honors have absolutely every right to conflict with the 4th and 2nd districts on this point. But with regard to the UCC and with regard to what the law and precedent has been, they're asking this court to effectively rewrite standing law so that they can foreclose on an instrument that, as a matter of law, we proved by preponderance of evidence that they do not own. There's a litany of cases that also stand for the proposition that we have the ability to challenge ownership of the instrument. If I'm going to give you one quote, it's from a case that they cite, actually, and I'll conclude with that, Your Honor. I'll conclude with that. The quote is, "A person seeking to enforce an instrument conveying an interest in real property must demonstrate he has directly or indirectly acquired ownership of the instrument. The majority errs, and I'm insisting upon this fundamental precept." There was the Shepherd who said that in Rogers, the case that they went ahead and cited to. I couldn't agree more. And I think when you look at that concept in the broader picture of other cases like Gillian, like your construction that we cited to heavily, you see that we can challenge ownership. And we can do it because Florida law tells us that we have a sufficient interest in outcome litigation, and that is the standard in our state, not privity. Thank you.
Thank you, Sam.